So I'm going to just do what Mr. Rankin had suggested. I usually am very flexible in timing, but within these meetings, I am sticking to a fairly strict time frame. Before every round, I will remind everybody how long they have, and I will stick to that with respect to everyone, which means that given the short time frame, I would ask the witness to please be succinct in his responses to the extent he can, and also to ask questioners to let the witness finish his answers unless he's really going on too long. And I will jump in at that point. With respect to the subject matter, let's all try to remember that the subject matter is the SNC Lavalin issue. I will allow some latitude, but if I see that you're not getting to the point, then I'm going to remind you to get to the point. So hopefully that's fair with respect to what Mr. Rankin asked me to remind everyone. And then with respect to the rounds, do I have unanimous agreement to go to 3 rounds as opposed to 2 for this witness? Yeah. Perfect. And then in the third round, I will again ask everyone before the third round, and perhaps I will even do it now. Does everybody agree that at the end of the third round, Ms. May and Mr. Weir can ask a question for 3 minutes each at the end of the round? I didn't
see you. And Mr. Plamondon as well can ask a question. Perfect. So 9 minutes at the end of the third round.
Mr. Butt's statement in English and French. Est-ce que tout le monde a la copie de... Okay, parfait.
Everyone have the copies? Great, thank you.
In the first round, so that's why I want to make sure before we start questions that everybody has it. Mr. Butts?
Chair, I just want to point out that my statement is longer. The written statement is longer. I did my very best to shave it all down to meet the timeframes. So the written statement has additional detail in it.
Perfect. Thank you. Thank you very much. Now, all members of the committee have copies? Yes. Perfect. So the first round, 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals. We'll start with Ms. Raitt. Ms. Raitt, the floor is yours.
Thank you, Mr. Chair. Thank you, Mr. Butts. Je sais que tous les Canadiens...
I know that all Canadians are paying close attention to the work of this committee today, and we're going to try to get some answers.
Thank you for noting the fact that your testimony is actually shorter than your written, but you did have an addition in your oral testimony that isn't in this, and I want to take you to it right now, and it's at the very beginning when you were talking about this notion of a legal of opinion, where you said, we had a view from the Justice Department that it would be appropriate for the minister, the Attorney General, to seek independent advice. And I assume I'd like to know when you received that view from the Justice Department, because it's a pretty interesting comment that PMO would get a legal opinion from Justice.
No, let me make sure I state that point clearly. The proposal was informed by a Justice Department memo, which I suspect you're going to want to talk to the Deputy Minister of Justice later about.
Okay.
That was where I believe it was an options memo, Ms. Raitt.
Yeah, and Jody Wilson-Raybould mentioned that, but how did you get possession of it, Mr. Butts?
I have no idea.
Okay, and do you remember around what time you received it?
No.
Okay, is it possible that it was before September 17th that you received it?
I don't think so, no.
Okay.
I remember it in the context, excuse me, sorry,
I
respect your question. Ms. Raitt, we've known each other a long time.
Yeah.
I believe it was in the context of the meeting of November 22nd, I think it was, between Elder Marquez and Mathieu Bouchard and Minister, I believe. But.
So just to clarify, there were 3 different types of legal opinions that your PMO staff were talking with Ms. Jody Wilson-Raybould about, according to her testimony, and they morphed from one type of opinion to another, starting in one kind of opinion in September, and then. But I'm not going to ask you about that. I'm going to ask you this: did anyone assist you with your testimony today?
Yes, I had legal counsel assist me, and some friends who have nothing to do with the present government. You guys are used to this. I'm not.
I know.
So.
Did you discuss this with the Prime Minister?
No, I did not.
Have you had discussions with the Prime Minister since you tendered your resignation?
He called me once to wish me well. I will say, Ms. Raitt, this is the longest I've gone in 30 years without talking to the Prime Minister.
Fair enough. You mentioned texts and email addresses. Given what we're seeing in another proceeding with respect to the government and the use of personal cell phones, can you tell me if the texts with the former minister were with a personal phone or one that was issued by the Government of Canada?
These were with my PMO phone.
These were with your PMO phone?
Yeah.
You already told us that you made contemporaneous notes detailing the conversations you had. Mr. Marquez and Mr. Bouchard were clearly on this file, for the most part, on point. Did you have many meetings with them?
No. I we looked through my calendar when I was preparing for, or I guess someone at the office looked through my calendar while I was preparing this testimony, and we could only find one meeting I had on this file internally.
Right. So what I'm troubled about, Mr. Butts, is you put out the view today that you were just asking the minister to take an external opinion to determine whether or not something or other, I don't know what the opinion was on, that was being sought. It's interesting that you mentioned Beverly McLaughlin in your written testimony as a potential person for external legal advice.
And I want to be clear on that, Ms. Wright, because I don't want to put Ms. McLaughlin or anybody in the government in a difficult position, and in no way that was meant in the context of the Jessica Prince meeting. I said it's someone like Beverly McLaughlin.
I see.
Yeah.
Okay. Back to my original question, though. Mr. Bouchard and Mr. Marquez and yourself, according to Jody Wilson-Raybould's testimony, kept looking for a solution, not external advice. It would seem that you determined that there was a problem. Prime Minister determined there was a problem. You communicated with PMO that there was a solution that was needed. But you tell us today that you weren't looking for a solution or an action. You just wanted her to take another opinion. So who is right, Jody or you?
I am not here to call anybody names, Ms. Wright. But I really don't think I would have used that word.
Okay.
I really don't. I can't be 100% certain. And if there were any problem that I felt needed to be solved, it was to make sure that all due consideration was given into both options. That's all. And if I can add, and I think this is an important point because, you know, people have made a lot of insinuations, and I think they've been based on speculation. I don't have a strong opinion. I mean, honestly, I don't envy either the former or the current Attorney General on this call. I really don't. I don't have a strong view either way.
Okay. Are you aware, Mr. Butts, that political considerations are not to be part of decision-making for the
Absolutely.
Attorney General?
Absolutely.
So why would the Prime Minister's office then condone several conversations, including the Prime Minister himself, bringing these elements into discussions with the Attorney General?
Well, I think there's a gray area in what you think is a political consideration, but I think you're also alluding to conversations I wasn't part of. I certainly never made any comment of the sort.
So the Prime Minister never told you, he mentioned...
Sir.
Thank you. The Prime Minister never told you that he had made a point that he was an MP in Quebec, and Mr. Marquez and Mr. Bouchard never told you, or Mr. Chin never told you that they told Ms. Wilson-Raybould it was about an election in Quebec, it was about winning votes in Quebec and concerns about votes in Quebec.
No,
They never mentioned that to you.
No, honest to goodness, that's not true, Ms. Wright. And I...
What's not true? That they never told you, or that they didn't say
nobody
it?
told me.
Okay, fair enough.
But can I just have a moment to answer this? And I think this is really important. I respect you a lot, Ms. Wright, and we've known each other a long time, not so well, but we're both from the same part of the country. And as is Ms. May, we could have a Terrorbish game if there were one more Cape Breton around this table. You know, we grew up around the same time, in the same place. And we know what it's like to see a company or a community collapse. Mm-hmm. And can you imagine if when we were kids and the coal mines closed or the steel mill closed, the best explanation someone could give us was that someone thought about it for 12 days in Ottawa. And that's what concerned us. That is absolutely what concerned us. We wanted to make sure it was the first time the law was ever being used, and we just wanted to make sure that every due consideration was given to both options.
As a lawyer, I give due regard to the decision-making of the Attorney General.
I do too. I absolutely do.
Thanks. Thank you very much. Always like exchanges between Cape Bretoners. We'll now move to an Edmontonian, Mr. Boissonneau.
Thanks, Mr. Chair. Mr. Butts, thank you for joining us today. We've heard from Canadians, and they can't help but draw a negative inference from your decision to step down as Principal Secretary. Mr. Butts, if you did nothing wrong, why did you resign?
Well, I believe I covered that in my opening statement, Mr. Boissonneau, and I also covered it in my public statement. I think that I was put in the position where I had to ask my colleagues to fight another colleague over accusations a colleague was making. And I think that that put the Prime Minister in an impossible position, given the nature of our friendship.
In your statement following your resignation and today, you categorically deny the accusation that you or anyone else in the PMO pressured the former Attorney General. Yet we've heard her testimony very clearly at this committee that alleges otherwise. Why should Canadians believe your version of the facts?
Well, I'm not, as I said to Ms. Wright, Mr. Boissonneau, I'm not here to cast aspersions on anyone or to suggest that anybody is deliberately misleading anyone else. I do believe that it is possible for people to draw different conclusions from the same experience. All I'm doing here is representing to you, to the best of my abilities, the truth as I see it and the events as they occurred. I supplied some context in terms of contemporaneous messaging between myself and the former Attorney General. But I'll also say this, these are really important jobs, but at the end of the day, we're all people. And when trust breaks down amongst people, I think that it's easy to see things that have already happened in a different light.
Thank you. In your statement, you said that it was important that the former AG be able to provide a rationale for not giving a remediation agreement to SNC Lavalin. In your mind, why was it important that she be able to give a rationale for not giving a remediation agreement to SNC?
Well, a couple of things. One is the legality of the legalities, the law on this is very fresh. And we thought it would be an appropriate step to get seasoned, eminent advice from a jurist that would help flesh out the process around the law. And that's all we were trying to do. There was nobody trying to make the AG make one decision or another.
So in your testimony today, as I understand it, your discussion with the former AG was about that need for a rationale, was the substance.
Yeah, I mean, it's the discussion I had with the AG was literally, as I recall it, as we were about to get up from the table after 2 hours of talking about a bunch of other things. And, but yeah, that's what it was about.
That's helpful. Ms. Wilson-Raybould shared her perspective that it was appropriate for colleagues to draw her attention to important policy considerations related to this issue, as you've done today, related to jobs. Yet when this pressure veered into the realm of provincial politics, she then deemed it inappropriate. So do you believe that successive meetings and raising such issues was appropriate?
What do you mean by such issues?
Well, members of the PMO talking about the fact that provincial politics are coming, that there's an election on the horizon.
I'm not going to pass judgment on what anyone else did, Randy.
Okay.
Mr. Boissonneau, excuse me.
Do you believe it was appropriate for people to speak with her at all after she had said that her decision was final on this matter?
I do not recall, as I said in my opening statement, that she ever said that. And I'm not sure why. I mean, my understanding of the law, and I will say to you what I said to Ms. Prince on
Sure.
December the 18th or whatever that was. I'm not a lawyer, so I'm always very hesitant to get into detailed discussions of the law. And that is particularly true in my interactions with the Attorney General. So I don't know what I can say on that, Mr. Boissonneau.
No, that's fair.
Yeah.
So in your role as the former principal secretary, you would have been privy to many important meetings.
Correct.
I'm interested to know if you ever witnessed inappropriate pressure on the former Attorney General.
No.
Would you have raised the issue with the Prime Minister had you ever witnessed a colleague inappropriately pressuring the former Attorney General?
Absolutely.
Thank you for that. We heard from Michael Warnick's testimony that while there may have been pressure, none of it was inappropriate, undue, or lawful. I think he said lawful advocacy. He stated that Canadians ought not to be worried about the rule of law in this country. Are you worried about the rule of law in Canada?
Absolutely not.
Why? Why not?
Because, and this is one of the things that I think is really important to keep in mind. I've seen a lot of things over the last 3.5 years, interfaces with other governments in other countries, and in a lot of places, public institutions, excuse me, are faltering and failing, and they're faltering and failing in countries that look just like ours. Canadians should have faith in their public institutions, and they should have faith in their public institutions because they work. I have absolute confidence in this committee, in Parliament, in the independence of the justice system, and in the professional public service, and in the powers of the Attorney General's office, which I want to say, Canadians should feel protected by the powers and conventions governing the relationships between these offices, not by the presence of any individual at any given time.
At any point, Mr. Butts, did the...
Sorry, your time has expired.
Thank you.
Mr. Rankin.
Thank you, and good morning, Mr. Butts. Thank you for being here. I'd like to read you from the letter of resignation by Ms. Philpott from 2 days ago and ask if you agree. She says, unfortunately, the evidence of efforts by politicians and or officials to pressure the former Attorney General to intervene in the criminal case involving SNC Lavalin and the evidence as to the content of those efforts have raised serious concerns for me. The solemn principles at stake are the independence and integrity of our justice system. Sadly, I have lost confidence in how the government has dealt with this matter and how it has responded to the issues. Finally, she says, I must abide by my core values, my ethical responsibilities, and constitutional obligations. I take it from your summary that you have a complete disagreement with her conclusions.
Well, I certainly don't have a disagreement with her conclusion in the sense that she's lost confidence. That res ipsa loquitur. And by the way, I should say congratulations on your retirement, Mr. Rankin.
Thank you.
I've been an admirer of yours for many years. Obviously, my opening statement details at length that I disagree with the former minister's perspective on this, yes.
All right. Now, listen, I want to talk to you about two events. December 5th, when Jody Wilson-Raybould met with you, both sought out a meeting, and she testified that I wanted to speak about a number of things, including bringing up SNC and the barrage of people hounding me and my staff. Do you recall her saying that?
No, I do not.
So you have no memory of that. Now, on December the 18th, 2018, you've talked about the Chief of Staff, Jessica Prince, meeting with you and Katie Telford. And according to a text that was read to us by Ms. Wilson-Raybould, which I'm sure you remember, she said, Jerry said, Jess, that's Jessica, there's no solution here that doesn't involve some interference. Then she says, I guess they're finally being honest about what they're asking you to care. Don't care about the public prosecutor's independence. Katie was like, we don't want to debate legalities anymore. They kept being like, we're not lawyers, but there has to be some solution here. What solution could possibly exist if it did not involve inappropriate political interference?
Well, I think I went through that in some detail in my opening remarks, Mr. Rankin. I have a very different recollection of that meeting. And I don't think I would have used the word solution because it's not one I would use in this context. But, my basic point to Ms. Prince was that if getting advice from someone like Beverly McLaughlin constitutes political interference, then it must be your position that you can't have a conversation about this file.
But if she rejected that, if that became clear at some point in time that her mind had been made up, would it not be reasonable for us to infer that that barrage of hounding, to use her words, was happening? Because she told people at the highest level of your office she wanted them to back off. Her decision was made up. Whether that was a good decision or a bad one is really not for us to talk about. It's just the way in which that was communicated.
Well, I would make a couple of points on that, Mr. Rankin, with respect. One is, I don't think it was possible for her to have her decision made. My sense, and as I was briefed by the professional public service at the time, was that she was obliged to bring fresh eyes every time new evidence arose. And
was there any new evidence? What new evidence? We've never heard of any new evidence.
There must have been, I am not aware of any, but there must have been
So you
some. There must have been some reason for the DPP herself.
So
to
you
take
would
a
accept
second
that
look.
if there were no new evidence, then it would be inappropriate to continue to push her, having demonstrated, as she had said so clearly by that point in time, that her decision as independent Attorney General had been made up?
No, I would not accept that. I would ask professionals for advice on it if that were in dispute.
Because you said, I think, in your testimony that up until the verdict, it's
Yes,
always appropriate
that is my
to talk.
understanding of the law.
All right.
Yeah. As I was briefed.
So my next point, Mr. Chair, is that the witness talked about a conversation with the Prime Minister concerning the removal of Ms. Wilson-Raybould from Cabinet. I point out to everyone that we don't have the ability. She refused to talk about that appropriately because the waiver that was given to her by the Governor in Council did not allow her to talk about it. So we only have one account of that very critical meeting. So I'd ask for the record that we call the witness back after the Governor and Council liberates her to talk about the balance of this, or we'll never know what truly happened. I just think that's obvious.
So, Mr. Rankin, with respect, my understanding is not that. My understanding is that I am covered by exactly the same waiver liberty, whatever you want to call it, that the former minister was when she was here. The event I'm describing, the two events I'm describing, the conversation the Prime Minister had with former Minister Philpott and with former Minister Wilson-Raybould happened successively on Sunday, January the 6th, and Monday, January the 7th. And my understanding is that the waiver covers the events up until the 14th.
So her testimony, people will recall, members will recall, was that she could not tell us about those events. So I'm told now that she can. So therefore, we need, with great respect, to hear account of the same, her account of the same event.
You're noted. Your time is now up, Mr. Rankin. I think it's up to every witness to determine for themselves what the order of in council covers. So I believe she. I believe that she did speak to these events at the committee, but we will take under advisement your comments. And I do note the witness's comment to Mr. Rankin, and I think from all of us who have served on the committee with him for the last number of years, his intelligence, his integrity have always been incredibly appreciated at this committee, and it will be a real loss to politics and to Ottawa and to the national parliament that you will no longer be here after the election. Thank you. We'll now go to Mr. Boissonneau again. Mr. Boissonneau.
Thank you, Mr. Chair. Mr. Butts, ministers face a ton of political pressure. I think you alluded to that. Former Solicitor General Wayne Easter indicated, quote, that there's always pressure in government, and what one person sees as pressure, another may just see as a day's work, end quote. Minister Freeland has said, quote, I always feel that when there are difficult issues, that if it comes to it, I should go personally to the Prime Minister to discuss them. I really think it's my duty to do that, end quote. Are you aware of any instances in which the former Attorney General raised this issue of pressure with the Prime Minister?
I am not, no.
Are you aware that she availed herself of any of the opportunities that she could have had with the Prime Minister to raise this issue?
I am not.
At any point, did the former Attorney General ever raise the issue of pressure with you directly?
No.
So we've heard testimony from the former Attorney General that she felt pressure, even after she asked or told us.
I'm sorry, your time has stopped. There's something with interpretation going on right now. Est-ce que l'interprétation ne marche plus?
Is the interpretation no longer working? We're just going to wait until the interpretation works again.
51 seconds, Mr.
Okay.
Boissonneau. C'est repris. Est-ce que vous pourriez confirmer que c'est...
Has resumed. Can you confirm that the interpretation has resumed?
It's working now, Mr. Plamondon? C'est beau, c'est beau. Okay,
ça semble-
merci, Berthaud.
Okay, yes, it seems to be working.
We heard testimony from the former AG that she felt pressure even after she asked members of the PMO to stop. As per her own testimony, after the September 17th meeting, she agreed to take another meeting with the clerk and her deputy minister. Then on September 19th, she asked that SNC send in a letter. Also on that day, she sought out Minister Morneau on this issue, and her chief of staff on September 19th and October 26th invited conversations between the Prime Minister's office and herself. Why did your former office keep speaking to her after the former AG had indicated she'd made a decision?
Well, as I outlined in some detail in my statement, I do not believe that we were aware that the AG had made a final decision at the time.
So what were you trying to achieve then? Getting an external opinion or getting more information on the issue?
I can only speak to the meetings that I was personally associated with or involved in, and in my case, I still don't quite get why getting transparent advice from a Supreme Court justice on this matter is controversial at all.
Okay, so constituents and Canadians are curious about how many meetings actually take place on a big government file, and you mentioned a file that's important to me. So, on a matter related to 15,000 jobs in Alberta and the West,
right.
billions of dollars of economic development, the idea to buy the TMX pipeline would have been a new idea, and that would have prompted a number of meetings between the Prime Minister's office and the Ministry of Finance. So, how many meetings, ballpark, would the PMO have had with the Finance Minister's office over the purchase of the TMX pipeline?
I feel like we had at least that many meetings with the affected Premier's office.
So what, 5 meetings, 50 meetings, 30 meetings? How many meetings in the first couple of weeks on TMX?
On the TMX acquisition, I would say, I wouldn't want to venture a guess,
Ballpark.
but it probably 100.
So is that normal for a file that's this big?
A file that big, for sure.
Okay, so affecting thousands of jobs.
NAFTA would be a week in NAFTA.
Fair enough. Okay, well, that's helpful. Now, I know that the AG has a different standard when it comes to pressure. So, Mr. Butts, on a matter of great importance that affects thousands of people on which the AG must make a decision, in your experience, what's the typical number of meetings that a PMO would have with an AG or their team?
Well, I think, and I say this with great appreciation of everybody involved.
Yep.
We're talking about people who had long-standing personal and professional relationships, and I seek to disparage none of them because I think it's hard enough to get people to contribute to public life in this country, and everybody involved has made great contributions. This was a novel law. It was the first time it had ever been used. So we thought the bare minimum we needed to do in order to look people in the eye who stood to lose their jobs was to make sure we had a good reason and to build process around that. And it's absolutely bare minimum to get the best advice you can when a decision affects that many people. And there's not much more to this than that, in my view, Mr.
Along
President.
that line, then, you take a look at a file like TMX, you take a look at this issue, you take a look at even the Supreme Court reference that you alluded to. So why only 10 meetings over 4 months on an issue this important?
I don't know.
Okay. Was there a coordinated effort within the PMO to try to get the former AG to change her mind on the SNC file?
No.
And you can...
100%.
How do we... 100% no? How can we believe that statement?
Well, one would expect that if such an effort existed, then I would have been aware of it, and I was not. And I know the people involved very well. Mathieu Bouchard and Elder Marquez are incredibly accomplished lawyers of sterling reputations. And it is inconceivable to me that they would engage in this sort of behavior.
I appreciate that. Final question. We've heard testimony and read in media articles that implies there was something inappropriate about raising provincial elections. I know there's one coming up in Alberta, for example. So in your experience, in the context of intergovernmental affairs, how are electoral considerations addressed on such big government issues?
Well, let me give you an example that is contemporaneous with the events you're describing. It was becoming really clear as we approached the end of the NAFTA negotiations that whatever settlement we came to on dairy policy was going to have a really large impact on the Quebec election. That did not stop us from signing NAFTA.
Thank you.
So that concludes the first round. On va passer au deuxième round des questions.